All right, welcome to the Utah Court of Appeals. Thank you for your indulgence with our break. We're much more comfortable now. We'll call the case of State versus Thaleb. Am I pronouncing that correctly?
It's Thaleb, Your Honor.
Taleb?
Thaleb with a
Thaleb
TH.
with a TH.
Yes.
Thaleb. Okay, got it. State versus Thaleb. It's case number 2024-0351. If I could have the attorneys who are making appearances today to say so for the record.
Lori Seppi on behalf of Mr. Thaleb.
Good morning.
Joshua Prince for the state.
Good morning. Okay, any questions before we begin? Okay, with that, we'll turn the time over to you, Ms. Seppi, and look forward to your argument.
May it please the court, Lori Seppi on behalf of Mr. Thaleb. Mr. Thaleb petitioned for expungement, and the post-sentencing court, in response, reopened the sentence judgment commitment, imposed a permanent criminal stalking injunction, and denied the petition for expungement. Mr. Thaleb appealed, and he asks this court to reverse. Once a judgment is issued, a court loses jurisdiction unless some rule grants jurisdiction. In this case, the state has raised two rules that it proposes granted jurisdiction to reopen the judgment. Rules 30B and 22E of the Rules of Criminal Procedure.
Do I have it right that either of them can stand on their own? In other words, if the district court is right about 30B, we don't have to do a 22E or vice versa?
That's correct. Our position is that the court was wrong on both fronts, that neither of the rules applied. Starting with 30B. 30B is designed to correct clerical mistakes. It's intended to reflect what was done or intended in open court. So, for example, it applies to a clerical error, which is an error in recording, but not a judicial error, which is an error in actually rendering a judgment. And the court will assess the error by the record prior to the judgment. In this case, 30B doesn't apply because the sentencing court's intent is clear on the record. It was express, and any error that the judge made was judicial. The sentencing court considered and rejected a permanent criminal stalking injunction. The court said that it was satisfied once it found that there was a civil injunction in place, and the state said that learning about the civil injunction also alleviated any concerns it had. The court then ordered Mr. Thaleb to comply with the stalking injunction that is in place. And if that for some reason goes away before probation is over, you're ordered to have no contact with the victim or her family. That language is express, it's clear. The judge believed the civil injunction was enough.
When I read the transcript, I felt like there could potentially be an ambiguity into what the concern was. The judge did say, I think that alleviates the concern. But in the broader context, one concern was, were we going to have the permanent injunction ready today? And we were maybe going to need to ask to hold another hearing or get the completed injunction later. It seemed to me that you could read that concern as either being, I'm no longer concerned that we need to get this in place today. There's something already in place that's sufficient for the time being, or it could be read as this alleviates a concern to even need a permanent criminal injunction at all. Can you help me see, is there a way to resolve that ambiguity?
I'd be glad to. So we believe there's no ambiguity even during that discussion, because what the judge said is the word but, right? I've made a note to myself to ask the state to prepare a permanent stalking injunction. But when I ran the name in chorus, apparently there's been a civil stalking injunction that becomes permanent, meaning 3 years. And here's a copy. And then the court just goes through and makes sure that this has been properly served. And then the state says the same thing. Now that we know that there's a civil injunction in place, I think that alleviates any concerns that the state has. But to the extent there was any ambiguity in that, even though, as I said, we don't believe there is, the court later cleared up any ambiguity when in imposing sentence, the court said to Mr. Thaleb that he was being ordered to comply with the stalking injunction that is in place. That's the civil stalking injunction. And if that for some reason goes away before your probation is over, you are ordered not to have any direct or indirect contact with the victim. So the order as it was stated in open court was you must comply with the civil injunction. And if that goes away, I'm ordering you to still stay away during probation. And the court didn't set up a separate hearing. The court didn't order the state to draft a permanent criminal stalking injunction. It was just comply with the injunction that exists.
So why don't you move on to Rule 22, which is their argument that this was an illegal sentence because the statute required that a permanent injunction be put in place.
Happy to. So Rule 22E orders the court to correct a judgment in certain circumstances. And one of those circumstances, if it omits a condition required by law. So if there's a condition required by law, the court can reopen the judgment. In this case, the stalking and permanent criminal stalking injunction statutes do not create a mandatory permanent criminal stalking injunction requirement.
Do we have to overrule Kropf to reach that conclusion?
No, because the statutes themselves have been amended since Kropf, and our position is that the statutes overruled Kropf. But if this court disagrees, then we've asked the court to overrule Kropf as an alternative.
The statutes haven't is it your position that the statutes have overruled what Kropf stood for at the time? Like Kropf was interpreting the statutory provisions, I'm going to get the years wrong, 2008?
But then it also looked at the 2012 amendments as well, right?
And it said things about 2012, and if what's happened since 2012 somehow changes that statutory scheme, how does it overrule what Kropf said about the 2012 and 2008 versions?
So our position is that the statute has changed, and there's very key statutory language that has taken the interpretation of Kropf and limited it to its historical place. But also, the language of Kropf itself, I think, was wrong at the time and continues to be wrong now.
When you
So
say,
even where the statutory language is the same in places, we'd still argue that Kropf is wrong.
before getting to Kropf is wrong, can I go back to that statement you said that it's limited to its statutory, or its historical place? Is its historical place, is it binding on the 2012 version, or only on the 2008 version?
We would argue only the 2008 version. It did look at parts of the 2012 version, but even that, it missed important parts of the 2012 version that I think should have impacted its analysis. So like I say, it was interpreting 2008. It looked a little bit at 2012.
But if it's looking at, gosh, this gets hair splitting on a wonk level, but if it's looking at the 2012 version, even if it was wrong about the 2012 version, it's still looking at the 2012 version. I suppose at that point it might be dicta, but it'd be pretty persuasive dicta, wouldn't it?
I don't think so, because even Kropf itself, when it was talking about part of the 2012 language, said that Mr. Kropf himself had brought up, said, this is in 2012. We aren't looking at it. And then it sort of opines on it. So it would be dicta, but I don't know that it's persuasive dicta, because it's not like it did a detailed analysis of 2012.
I mean, just getting to sort of the brass tacks of the whole thing, as I read Kropf, I mean, you're right, Kropf looks at a lot of different pieces of the statute, but it really seems to zero in on 9B. And 9B is present in all the different versions we're talking about, and it really just seems to zero in on that first sentence. A permanent criminal stalking injunction shall be issued by the court at the time of the conviction. And it just feels to me like what Kropf is really saying is that sentence is so dominant that all these other sort of arguments we've made about different subsections just don't overcome it. And if that line is the centerpiece of Kropf, and it's a through line through all the different versions of statute, then that would answer the question before us still, wouldn't it?
No, I don't believe so, because I think the answer is in the question, that Kropf was so focused on that one sentence that it sort of colored its reading of the whole statute. And I think that's where the problem in Kropf arose, and why Kropf should be overruled, and why the new statutory language and the old statutory language supports our position.
Well,
So-
let me ask another sort of question about the scope of Kropf. In paragraph 22 of Kropf dives pretty hard into interpretation of subsection 11, which was a new addition in 2012. So, Kropf didn't have to go there because this was part of the 2012 additions. This thing about if, beginning the second sentence, if the court issues a permanent injunction but declines to address custody and parent time issues. And the court goes on in that paragraph to be very clear about its interpretation of this new 2012 language. And the court even says it is clear that the legislature used if to refer to the possibility, and so on and so forth. That ruling seems binding on us.
So
It's not just dicta, right? The court is actually interpreting that language and telling us what it means.
So our position is that it's dicta at best. I mean, right before in context, it is clear, it says Kropf fails to acknowledge that this language was added in 2012 as not contained within the criminal stalking statute that is applicable to Kropf, the 2008 version. And as I was stating earlier, it only looked at some parts of 2012. Some of the other amendments to 2012 were also very important that the court didn't analyze. And to kind of bring it back, I think where Kropf went wrong is focusing on that one sentence. The sentence, a permanent criminal stalking injunction shall be issued by the court at the time of conviction. It was a little different in 2008, but it's essentially the same language. And the court looked at that and said, we see the word shall is mandatory. And then despite acknowledging other parts of the statute that seemed more discretionary, the court went with that. And I think the problem is that the statute sort of lays out a three-pronged instructions. One, what triggers a permanent criminal stalking injunction? Two, when should that injunction be issued? And three, how is it issued? So the first part is the application. The following serves as an application. So if there's a conviction for stalking or attempt under the 2017 and the current versions of the statute, then that triggers the analysis. The second step is the timing.
And on that,
that's-
and I'm sorry to cut you off, but on that, you would have us take the word application literally. You're saying it just has to be asked for by somebody.
So the word application itself denotes discretion. And what we're saying is that it's here, it's automatic. If there is a conviction, the application is triggered. I see my time is running out. Can I finish
Go
up?
go ahead and finish answering the question, then I have at least one more, and we'll see where we're at after that.
Great. So application denotes discretion, it triggers. And then second, when the court says that a permanent injunction shall be issued by the court at the time of conviction, that is immediately followed by a condition. And that condition is unless the defendant requests a hearing. And then if the defendant requests a hearing, that hearing will either happen immediately or later, depending on whether the victim asks for it or good cause. So that's a timing provision. Either it's going to happen now or it's going to happen later. And if the defendant requests a hearing, then that takes you to the third section, which is how to impose this injunction. And this is the critical language. A permanent criminal stalking injunction shall be issued by the court granting the following relief where appropriate.
Sorry, what subsection is there?
That's subsection 10.
10, okay.
That was enacted in 2012. It was still in effect in 2017. It's still in effect today. The critical language here is where appropriate. It is the judge's opportunity at that point to look at the different conditions that are available and say all, some, or none of these conditions are required. And they're only required, as it says in subsection 10C, if the court considers them necessary to protect the victim. That's the operative language. That's where we'd like the court to look. Where necessary, and it's necessary if the court considers it necessary to protect the victim. Where Kropf went wrong was to say that you had to impose at least one condition.
Can I get your thoughts on the state's point regarding what they're calling statutory stare decisis, meaning that Crop came out in 2015. It's been 10 years now, almost, 11, or 2026. And the legislature's had 10 opportunities now to change the statute to make it more clear in your direction, if that's what they intended to do, and they haven't. What should we make of that?
So I think they have, right? First, the language that Kropf didn't talk about, this where appropriate language, and when it's necessary to protect the victim, that language Kropf didn't talk about. That was enacted in 2012. And then in 2017, and after that, that language has still been there. It hasn't been changed. And then in 2022, the court moved the statute to a new provision and provided directing language to the new provision. And the language didn't change. It was some stylistic changes, but that 3 steps, application, timing requirement, and what conditions to impose, that language essentially remained the same in the new statute. But the directing language that directs the reader to the new statute now says a permanent criminal stalking injunction limiting contact may be filed in accordance with this new statute. May is discretionary language. So I think the legislature has said that this is discretionary. Kropf has not been relied on. It's been cited 4 times, not for this provision. I mean, who knows how aware the legislature was of it, but I think the legislature has made clear through where appropriate, necessary to protect the victim, and may be filed. That's all language of discretion on top of the other language that we've talked about, application, and that when they use the word shall, they create a condition. Shall issue unless the defendant requests a hearing. It's a timing requirement.
Okay, thank you, Ms. Seppi. We appreciate your argument. We'll hear
Thank
from
you.
you later on rebuttal. Mr. Prince.
Thank you, Your Honors, and may it please the Court. My name is Joshua Prince, appearing for the state. The clear legislative purpose of the permanent criminal stalking injunction statute, as reflected in the statute's unambiguous language, is to protect all victims of stalking and attempted stalking through the mandatory entry of a permanent criminal stalking injunction that is entered at the time of conviction. The legislature sensibly concluded that a mandatory permanent criminal stalking injunction is the only way to guarantee that all victims of stalking and attempted stalking are protected.
Can I just start you where Ms. Seppi just left off? I'm going to throw the softball and then I'm going to play with it a little bit. I'm assuming you agree that the legislature could overrule Kropf if it wanted to.
Certainly.
Okay, so if the legislature, we're just going to work off the legal fiction that they're reading everything we write. If the legislature reads Kropf and thinks to itself, no, we want to make this discretionary, not mandatory. Ms. Seppi just gave us the laundry list. They added a bunch of language that feels conditional, or that feels not mandatory, where appropriate, where necessary, may be filed. In your view, if the legislature was trying to make this non-mandatory, how else would it have done it other than what they just did by adding language like may be filed, where appropriate, where necessary? Like, how could it have been clearer?
The clearest way for the legislature to amend the statute to make the permanent criminal stalking injunction discretionary as opposed to mandatory would be to amend Section 9B, what is now in 78-7-902, to use the word may. As Your Honor recognized in my friend's argument, that was the language that that this court in Kropf threw the most weight behind. And that was the language that needed to be amended before this court could look to other provisions of the code to override Kropf's clear interpretation of subsection 9B. Turning to the particular provisions that my friend pointed to, the use of the word where appropriate merely allowed the district court to consider particular provisions, but at any point, the one thing that subsection 9B did require in 2017 was the district court enter an injunction requiring the defendant not to stalk the victim further, Now, that is going to look different depending on the particulars of a given case. In subsection 9A, if you read its text, it says that the following serve as an application for a permanent criminal stalking injunction. And here's the money language as Crop recognized in subsection 9A, limiting the contact between the defendant and the victim. At the very least, something must be done when entering a permanent criminal stalking injunction, limiting the victim's contact with the defendant. and
But
vice versa.
I suspect that what Ms. Seppi is thinking right to your left right now is that if we're going to look at 9A, the starting place there is the word application. The following serves as an application for a permanent criminal stalking injunction. It is a really odd linguistic choice for the legislature if it thinks that this is mandatory to put the word application in there at all. I can't think, maybe there's an obvious one, maybe it would give it to me. I can't think of another statutory example that says that you need to file an application for something that the court is required to just do on its own anyway. That's weird to put those things together, those concepts.
The closest example that I've been able to find in the Utah Code, Your Honor, is the registration of voters. So the Utah Code provides that a voter shall apply to register to vote, and then upon application, when referring to what the clerk must do upon receiving the application, it says that the clerk shall register each person who is qualified, and essentially who has already applied. So a person is not registered to vote automatically unless the person that wants to vote affirmatively applies. But once that application is submitted, as long as the qualifications are met, then the person must be registered by the clerk. There's an affirmative duty in conjunction with the application.
So you're saying that once the conviction is entered, and the conviction qualifies as the application, and that's it. That's why the legislature is using that term, application.
That's exactly right. And we also think that the word application is merely a remnant of the fact that the stalking injunction was historically a civil remedy that was available to victims of stalking. The legislature in 1999 amended the statute to make this a criminal provision as well, but they maintained the word application as a callback to its civil historicity. And that flows just from a plain reading of 9A in conjunction with 9B. The way that the stalking injunction has worked since it was enacted was once a person is convicted of historically stalking, and then in 2017, it was amended to include attempted stalking, the sentence for which we're before the court today. Once the conviction is entered, once the application is received by the district court no longer has discretion. It has to grant the application by entering a permanent criminal stalking injunction. And the way that the legislature gave the district court discretion and avoided all of the due process concerns that Mr. Thaleb has raised in his appeal was by giving the district court discretion to consider the particulars of a given case when determining the terms. That's what this court held in Kropf, and the state maintains that that's the correct reading of the statute today. The fact that the 2020 amendments moved what was the language of subsection 9B to another statute only further informs the conclusion that the stalking injunction, the permanent criminal stalking injunction, was to be treated sort of in kind with the civil injunctions that were originally in place. So at the very least, the stalking injunction requires limiting contact with the victim. All agree that if the statute at issue in 2017, when Mr. Thaleb committed the attempted stalking, required the entry of a mandatory injunction, then Rule 22E applies. The clearest way to resolve this case is to affirm the correction of the illegal sentence under Rule 22E, because that is the rule that Kropf itself held was directly on point in a situation such as this, where a mandatory provision is excluded from a sentence. But even if this court disagrees on whether the district court had jurisdiction to amend the conviction, the court's public interest holding is also something that would require affirmance here, because the district court did not abuse its discretion in concluding that Mr. Thaleb, that it would not be in the public interest to expunge Mr. Thaleb's conviction. The court found several facts salient in its analysis of the public interest.
Did it find, there's an interesting wrinkle that's brought up in the reply brief about what facts are appropriate for our review. Did the court find those facts, or are you drawing them from documents from which there has not been a finding?
So the court addressed three particular facts in its conclusions. Number one, the court found that the conduct was persistent. The court on the record did not exactly say what it considered to be the persistent findings, but the only way to possibly read this, given the limiting language of the plea agreement itself, was that the court considered everything that was before it, which included the victim's letter, which included the pre-sentence investigation report. And if you compare the facts as we raised in our brief to those facts that are admitted in the reply brief, they're fairly consistent with one another. There's not a lot of disagreement about what Mr. Thaleb agreed to when discussing, for example, information in the pre-sentence investigation report. The next thing that the district court considered was that Thaleb referred to the victim as his wife and referred to the victim's current husband, despite the fact that they had been separated for years. The court found that this showed that the victim, or that the defendant was still thinking about the victim and had a continuing thought pattern with respect to the victim. And finally, the court looked to the petition for expungement itself, where the defendant minimized the emotional distress that his actions caused the victim. All of these things were well within the district court's discretion to consider, and it was not an abuse of discretion to look to other things before the court beyond the facts that were actually pleaded to. This is not just the state's judgment. The legislature itself, in the plain language of the statute, indicated that the best way to protect victims was to require a permanent criminal stalking injunction. That itself is a public interest finding, essentially, of the legislature. Even if Thaleb's reading of 106.5 is correct, contrary to Croft and contrary to the plain meaning of the statute, that a permanent criminal stalking injunction is not mandatory, at the very least, the legislature determined that stalking and attempted stalking are serious enough offenses because they take place over a significant course of conduct to require the district court to consider entering an injunction. And so the district court, to look at the entirety of the offense and to look at everything before it and determine that the public interest would not support expunging Mr. Thaleb's conviction, was entirely consistent with that legislative pronouncement as reflected in the statutory text. Now, if there are no further questions, we urge the court to affirm. The district court had jurisdiction to amend the sentence, and the public interest holding of the district court was correct in any event.
Okay, seeing no further questions, we'll consider it submitted from the state. Thank you, Mr. Prince. Rebuttal, Ms. Seppi?
I'll start with the expungement issue and then come back to the interpretation issue as I have time, as long as the court likes my use of that time. We would ask this court regarding the denial of the petition for expungement, if the court agrees with us that the statute does not require a permanent criminal stalking injunction, we'd ask the court to remand and let the district court, without the overlay of a permanent criminal stalking injunction, to consider the petition anew. But that being said, I think it's really important when the court is considering this case to look at Mr. Thaleb's actions. Mr. Thaleb said that he had no intention of ever contacting the victim in this case again. He pled guilty quickly. He was successful on probation. It was terminated early. After probation terminated, he never tried to contact her. After the civil injunction terminated, he never tried to contact her. For years, everything was fine. The only reason this case came up again was because Mr. Thaleb petitioned for an expungement. He was a pro se litigant doing the best he could, but his words speak quieter than his actions. His actions show his seriousness in this case and how he's not going to violate. The district court's finding, to the extent it was a finding, that his conduct was persistent. Yeah, he pled guilty to conduct in 2017. He acknowledged it, he pled guilty, and he never did it again. Our position is that that is not persistent, and to make that finding was clear error. The finding that he had a continued thinking pattern was based on the fact that in his pro se paperwork, he referred to the victim as his wife. Everyone was confused about it. They had been married according to a Muslim ceremony. The court, in the hearings, granted as part of this permanent injunction that was issued, his ability to file divorce paperwork without violating the injunction, so everyone was confused about it. It made sense that he wouldn't know whether they were still married or not. That shouldn't be held against him. Holding it against him was clear error. And finally, the minimizing distress that he caused, finding that was, I think, referencing his statements in his pro se paperwork that he had never pled guilty to or admitted threatening behavior. That's true. He never admitted to or pled guilty to actual physical threats of violence. He admitted the conduct that he did. The conduct that he admitted to was similar to the conduct that the victim alleged. So we'd say that is clear error as well. My time is up. Unless the court has questions, we'd ask this court to reverse.
Okay, seeing none, thank you, Ms. Seppi.
Thank you.
We appreciate the arguments in this case. We'll take this matter under advisement and get you a decision as soon as we can. Thank you for coming down today. Court's in recess.